Good morning, good afternoon. Thank you all for joining this latest in a series of SIAC webinars on virtual hearings and other developments in international arbitration during the pandemic. I know that some of you, perhaps all of you, have seen other webinars, but this one is special. This one is special not just because it's SIAC, which is a special global institution, but also because of the quality of the others who are speaking on this webinar series. We have a uniquely international, also a uniquely experienced set of speakers. You can, of course, see them all on your screen at the moment, and equally they require no introduction. But Michael Mcilrath is in-house counsel, formerly at General Electric and now at Baker Hughes, with a vast experience from the client's perspective in international arbitration of all sorts. He has particularly interesting observations about arbitration in Europe, but also elsewhere in the world. Guled Yusuf requires no introduction. He has a vast experience both at Allen and Overy and elsewhere in international arbitration, both in Africa, the European jurisdictions that you're all familiar with at SIAC and elsewhere. Fernando Serrano at Latham's and Watkins has particular experience in Latin America, but also in Spain, France, elsewhere in Europe where he's practiced. Mohammed Wahab is the leading international arbitration practitioner, a real expert in North Africa, but also elsewhere. Evgeny Rashev is one of Russia's leading international arbitration experts, and we're especially privileged to have him here today. Perhaps he can touch on recent amendments to Russia's arbitration legislation. I think that is enough by way of introductions from me. I think we all of us, all the participants, owe special thanks to all of our panelists for having both agreed to participate in this and share their vast experience with us. We all know that the pandemic has changed international arbitration to some extent. The historic practice of in-person live hearings has been altered somewhat. Perhaps that will again change in the future, but we've all heard about virtual hearings. We used remote testimony for some witnesses prior to the pandemic, but now, to a greater extent than ever, entire hearings, so-called virtual hearings or remote hearings, are being conducted using new types of technology. We've all tried to cross-examine witnesses by Zoom or WebEx, BlueJeans, or something else. And the object of today's panelist discussion is to explore experiences in different parts of the world with that technology. Explore both how, as a practical matter, virtual hearings are conducted, but also observations, insofar as any of the panelists have them, about how local courts are approaching virtual hearings and how, in their view, local courts in their jurisdictions, the jurisdictions that they are most familiar with, would approach issues of virtual hearings in both annulment and recognition proceedings. There's no particular order, but perhaps we can start in the order that I introduced the various panelists. Michael, thoughts from Florence?
Well, thoughts, that's a pretty general question, Gary. Thoughts from Florence. I could start with the Statue of David at that point.
Our participant number just crashed.
I'm not here?
No, we're doing fine.
Okay, all right.
Let's hear about David.
So the Statue of David, it's there, it's doing quite well. It's been around for centuries, and it will, hopefully continue to be there for centuries, as will arbitration. But I think that arbitration, unlike the Statue of David, which is made of marble, this is an interesting metaphor I hadn't thought of before now, but it is not in stone. It is something that is not only will change, but has changed dramatically in the last few months. Before we all joined, Mohammed and I, who worked on a few projects together at the beginning of the pandemic, were commenting that we're amazed that it's not only is it still 2020, but this was only a few months ago that we were having these conversations. And we seem to have like catapulted ourselves into a different reality today. So I would have just a quick few observations from the user perspective, from the client in-house counsel perspective. One is that, as you can imagine, most large companies, we have a process for reviewing our disputes. That's in compliance with filing requirements and just in good practice. You need to know what litigations you have, how you're reserving them, and every company does this in different ways. This is a time of year at the end of the quarter where we do that. And so I had, with respect to court litigation, the easiest quarterly litigation review everywhere. It was just like, courts were suspended, that's in Spain, courts were suspended, Italy, nothing happened. Arbitration and mediation, that's not the case. Most of our arbitrations, things that are in arbitration or mediation, have continued, some with some delays, but even where there has been delay, this is interesting, is that there's been discussion. So there's been interaction with the tribunal. And I think that we're actually seeing a time where there seems to be more dialogue between parties and tribunals. And I like that. I like the fact that the tribunals are engaging with us. They're asking us, how do we handle these situations? We have scheduled, we have some hearings coming up. We don't know if they're going to be in person or virtual, but I think people are comfortable that if they are virtual, we're comfortable figuring out how to do it. There are a lot of interesting case management techniques that we're beginning to see being used. This is stuff that's been available for a long time, like getting experts to work together, having parties discuss perhaps reducing issues in dispute, so that you reduce the weight of the issues that would be submitted to the virtual hearing if you have one. But we should have been doing this anyway. And yet now we're really seeing people beginning to embrace this. And I sort of think that it's a good thing that this crisis for arbitration happened at a time when the technology is not perfect. That we all recognize that there are glitches, there are imperfections. And so because of these imperfections, I think that we're seeing more innovation taking place with case management, how arbitrations are being conducted. Because if we had virtual technology and we could all go into a hologram or something and interact online, we would take any current good and bad practice and just shovel it into the online virtual experience. Instead, what I'm seeing, and I hope other people are seeing this as well, is a kind of a rethinking is what is its essential, what do we need to do, more dialogue, and then so if we do get to a hearing, how is that time more efficiently managed? And so my big question really as we get out of this is how do we keep from going back? You know, now I think it's not just a question of whether virtual can be used. I think virtual is now beginning to be the default. Case management conferences, I mean, if anybody this happened to me as recently as December. Somebody saying, well, we have to get together. It's a 2-hour case management conference. We should meet in London. Important for have this. I think if anybody suggests that today, even after or in a year or 2 years after this pandemic, you will look at them as if they're crazy. Why would you fly all this time to get together for a 2-hour case management conference, for example? It's different from a merits hearing, but a lot of things, I think people we don't want to go back. And so it's my question really now is how do we capture and build on the momentum with respect to not just virtuality, but just the general innovations that we're seeing that are taking place?
That's a great set of questions, and I think the other panelists are uniquely positioned to answer that. A couple observations on what Michael said. Some people say winter may be coming. I think the takeaway from Michael's observations, and I have to say these are my own personal observations as well, is that maybe summer is coming or spring is coming for international arbitration. And the reason I say that is both because international arbitration is working now, is demonstrating that it's working now during the pandemic when the other means of dispute resolution, especially international dispute resolution, national courts, aren't really working. There's some exceptions, of course, but in general, as Michael's litigation review demonstrates, most national courts, in contrast to arbitral tribunals, are closed for business. Of course, we all hope that the pandemic isn't permanent, that this isn't the new permanent state of affairs, and that at some point stores, restaurants, and courthouses will reopen. But even then, I wonder, and I've heard domestic practitioners speak to this, whether national courts won't go right back to the way of doing things which they've always done. Some countries where you have jury trials, that's necessary. They will have in-person hearings. But I think international arbitration, as Michael has said, will permanently learn and permanently use the procedures, the lessons that we've gathered over the last months. And as a consequence, CMCs and in appropriate cases, hearings and testimony will be conducted virtually. That will be, because of the efficiencies and the expedition that it brings, a further reason to use international arbitration as opposed to domestic courts. At least that is a hypothesis that perhaps the other speakers can address. Both, therefore, and Guled, perhaps you can speak to this, both in terms of what's happening now, especially in the regions you're most familiar with, and what do you foresee down the line after national courts reopen for business?
Thank you very much, Gary, and thanks to the organizers as well. I mean, before delving into sort of recent practice in Africa in any detail, it's worthwhile providing some background on the situation in Africa at the moment, as it's received little coverage in the international press. I think thankfully for the most part, no news is good news. The continent has not been hit as hard by coronavirus as other regions, despite predictions by many experts who had warned that the continent would be hit hardest. Most African nations staved off the initial spread of the virus for several months, partly by closing borders early, banning public gatherings, and in some countries effectively tracing contact using past experience of infectious diseases. So judicial and arbitral proceedings have been impacted to different degrees on the continent, depending on the severity of the lockdown measures adopted. On the one end, you have South Africa that had an extremely strict lockdown. And on the other end, you have President Magufuli of Tanzania, who declared that there are no cases in his country, which unsurprisingly has been met with some skepticism. It would be a tall order for Mohammed and I obviously to cover 54 countries on the continent, so I'll limit my remarks to South Africa and Kenya. In Kenya, court operations were scaled down from March and replaced by virtual hearings. The courts have only recently partially reopened in the last few days, meaning that virtual hearings will remain the norm and a limited number of cases will be heard in person with strict health measures in place, such as a requirement to wear a mask and temperature checks. Kenya was actually very quick to embrace virtual hearings by video conference. In March, the Chief Justice issued practice directions on electronic case management to guide the integration of IT in judicial proceedings. The practice directions stress that virtual hearings should be managed in an efficient manner and indicate a desire not simply to replicate in-person hearings, but to improve on them, which I think is quite an important message. On-site services at the Nairobi Center for International Arbitration remain suspended, but the NCIA is urging tribunals to consider applicable provisions of the NCIA rules and regulations and to engage parties for remote e-enabled virtual procedures or document-only proceedings, as many other arbitration centers have around the world. Similarly, in South Africa, a directive was issued specifying that only urgent applications and matters may be heard in open court, and that judges are given discretion to hear matters through video conferencing or other electronic means. However, it has been suggested that some courts have not exercised that discretion to organize virtual hearings and are experiencing a backlog of cases. The experience of colleagues in South African virtual hearings has been very good thus far. The South African Department of Justice has observed that the present circumstances have necessitated the accelerated implementation of projects aimed at modernizing and digitizing judicial services. So I think in many jurisdictions, you'll see the long-lasting effects of adopting new technologies. As in all other regions, the following questions have arisen in Africa. Are virtual hearings permitted under the relevant arbitral rules? Do virtual hearings present due process concerns? And will any eventual awards be enforceable? Are virtual hearings here to stay? Do arbitral centers need to revisit their rules to accommodate virtual hearings? So first, in relation to permissibility of virtual hearings, I think most institutional rules afford tribunals significant discretion in how they conduct the hearing. They're not always mentioned sort of expressly, but certainly the SIAC arbitration rules in relation to emergency arbitration make specific reference to video conference hearings. Second, in relation to due process and enforceability of awards, virtual hearings in and of themselves, in my view, do not automatically run afoul of due process requirements. It is entirely feasible for the parties to be treated with equality and for each party to be given a full opportunity to present its case in a virtual hearing. I'm not aware of any national courts on the continent that have opined on the legitimacy of virtual hearings or the enforceability of awards coming out of virtual hearings. But I expect the fact that most domestic courts have adopted virtual hearings themselves provide some comfort in that respect. Ultimately, virtual hearings conducted in a haphazard and lopsided manner will obviously present the same issues as an in-person hearing conducted in the same manner. There are, of course, unique challenges that present themselves in virtual hearings, but I would like to think that many of those challenges can be identified and addressed by means of careful planning. Two noteworthy examples of difficulties, I guess, that are unique to virtual hearings are technological disparities, inequalities between the parties, and variance in lockdown measures or restrictions, especially now that various jurisdictions are opening up at different rates. Before we started the video conference, we had a chat between the participants about sort of the lockdown measures in the various jurisdictions that we're in. And you can imagine a scenario in a few months where one party is under a severe lockdown and another is in proximity to the tribunal and isn't under a severe lockdown. Will the parties then be open to having sort of a hybrid approach? Will that be permissible? Will that raise any concerns about equality of arms? Those will be interesting issues to resolve and consider. Third, as for the future of virtual hearings following the pandemic, I expect that we'll all continue to use some of the technologies and practices that have recently gained popularity. However, I do not expect that arbitral practice will change drastically. It's not the case that we went from purely in-person hearings to entirely virtual hearings. For many years now, actually, the community has already had virtual procedural hearings and witness testimony by video. Furthermore, I'm very skeptical that virtual hearings will become the norm once they aren't necessary, notwithstanding all the personal space that we now enjoy when we're conducting hearings and the insights that we get into everybody's personal decor at home. Instead, I think that this period will accelerate the adoption of various technologies in arbitration, and it may differentiate, as Gary mentioned, arbitration proceedings from court proceedings. You know, Gary famously observed that parties' preference for arbitration stems from the 5 E's, including that arbitration is efficient and expeditious. That may not always be the case, but I think that proceedings and submissions have had to be streamlined recently. There is an opportunity to demonstrate the efficiency and flexibility of arbitration during a time of crisis. Arbitration may prove to be a more popular form of dispute resolution following the pandemic if we all do our jobs well. Finally, in relation to rule amendments, as I already mentioned, I think that many rules provide sufficient discretion to tribunals, but it would cause no harm to address virtual hearings expressly when revising a set of rules in order to underscore their legitimacy. I don't think there's an immediate need to go back to the drawing board and make drastic amendments. So I'll leave my comments there for now.
That's very helpful, Guled. And we now know that there are not 5 E's, but there are 6 E's, because arbitration is not just more expeditious, efficient, expert, enforceable, and even-handed, but it's also more electronic because of our use of virtual technology. Mohammed, your thoughts on both those observations, but also what's happening in North Africa?
Absolutely. Thank you very much, Gary, and delighted to be here and to build on what you've mentioned. And Mike and Guled follow the same approach. As you mentioned, people have been speaking of winter is coming, as your very famous words. And I think the arbitration Snowpiercer has not stopped. So it's proven very efficient and adaptive as a process during these challenging times. And I agree with Guled that Africa, I must say, has been doing very well. Why very well? Because it has accelerated the pace of access to technology, modernizing the infrastructure, and being capable and able to deal to the extent possible with the available resources with this crisis in terms of COVID-19 pandemic. Now, I will limit, as I mentioned, as agreed with Guled, my observations, of course, to Egypt. I'll also mention Nigeria and Rwanda, because there are some interesting developments. And then I probably address a little bit of the excellent efforts as well in the UAE, as the amount of other countries in the MENA region. So in Egypt, we have never went into a formal lockdown mode. The government has continued to do its best to keep the country open for business, subject to restrictions that have been either stringent or less stringent or more relaxed, depending on the weeks over the past 3 months that the government has been monitoring the rise in the number of infections. And to that extent, people have either chosen to go into a self-imposed lockdown, like myself and many other practitioners, working virtually, or have been going out and doing in part what they're familiar with in terms of work. Now, courts have closed for some time and are reopening up now. We have not moved to the online environment in terms of the courts yet. There have been efforts to, let's say, use technologies to bring about proceedings online, but it's not easy. Egypt is a huge country with a huge population and requires a lot of investment in the infrastructure. Quite interestingly, and quite unbeknownst to many, in 2019, we have had an amendment to our economic courts law well before the COVID-19, whereby the first time we've made a reference to electronic proceedings, filings, and potentially using technology to appear before the court. Now, this is yet to be tested and put in effect, but it's a step forward, definitely. On the other end, arbitration has been thriving. There have been cases proceeding virtually. And as Guled has mentioned, the comfort that courts themselves have faced the problem of being unable to proceed physically gives a degree of comfort that it is very unlikely that a virtual hearing or proceeding virtually in and of itself would be a valid ground to set aside or challenge an award. There must be more evidence as breach of due process, substantiated one, rather than the due process paranoia. Now, what has happened, quite interestingly, in situations where parties have insisted jointly on a physical hearing, and that's perhaps a practical insight on what has happened, is that arbitrators have been quite innovative in issuing directions about how the hearing will take place. So in one case, which is quite interesting, they have limited the number of appearing counsel, given the size of the room and the physical distancing, to that is what is strictly necessary. So arbitrators have instructed that no more than a couple of counsel would be appearing in the room on behalf of both parties if they want to proceed physically, which is interesting. And of course, counsel have had a go and saying, it's a breach of due process. They told them either we go virtual, or given the size limitations of the room, we have this limitation on the number of counsel. Now, the arbitrations, as I mentioned, have been proceeding virtually, no issue. Now, moving from Egypt to Rwanda, Rwanda has been at the forefront of using technology well before COVID-19. So courts are well equipped with computers, well equipped with internet access, and going virtual was not difficult for them. Now, of course, in reality, going virtual with courts was limited primarily to 4 territories or provinces, mainly Kigali, the capital, Ngoma, Hayu, and Musanze. So not the other parts of the country. The courts went into lockdown as well for some time, but there were hearings and decisions delivered virtually, including in April 2020. Nigeria, which is another big country in Africa and a huge economy, as well, the courts were not very well equipped with the needed technology to immediately go online. So there was closure, and there is a degree of a continued closure, except that they deal with very urgent cases and matters as and when necessary with skeletal and limited staff. That said, I have to say the quite innovative thing in Nigeria is that on no less than 2 occasions in the territory of Borno State, which is Maiduguri, they delivered towards the end, precisely on the 27th of April, they had a virtual hearing with a decision in a criminal law case that was done totally virtual. And then the second one came from Lagos during the first week of May, delivering a judgment regarding a death sentence virtually. So courts are picking up gradually. They are adopting practice notes and guidance on how to proceed virtually, as well in Nigeria. And I think the next weeks we'll see not just an opening up, but more of an expedited access to virtual and electronic means of doing justice. That said, arbitration continued to proceed virtually even on domestic cases. I was presiding one tribunal and we went virtually. There were no concerns whatsoever about this. And even Nigerian law is not against that. As has been mentioned, there are some laws that are silent on the matter. It has not been contemplated. But depending on the jurisdiction, silence in and of itself could be good news that there is no prohibition on proceeding virtually. Even Tanzania, with their latest arbitration law that came out in February 2020, they made no express reference to technology, though one would not be surprised if virtual hearings were not considered at all in breach of the law. That said, the final point I would make in the UAE, we have a number of cases now, either as arbitrator or as counsel. And I think even though courts, we have to distinguish, because the DIFC courts have expressed references within their procedural rules regarding electronic means and proceeding virtually. The Dubai courts or Abu Dhabi courts or other courts in the other Emirates do not have express provisions. But again, one would doubt, we are yet to wait for a test case, that virtual hearings in and of itself would be considered a ground for any procedural irregularity or anomaly. But again, the UAE is opening for business and is adopting very well-measured measures in a way regarding doing business, which continues to be the case as a hub for international arbitration. These are the initial comments I have, noting again that we don't have, as Guled has mentioned, a test case about what courts will be doing, though the fact that courts have experienced and continue to experience the problems with COVID-19 gives great comfort about the future of upholding virtual hearings on the continent and beyond.
That's very interesting, Mohammed. Just one follow-up question. Some institutional rules, the ICC rules, for example, make reference to the need for an in-person hearing. That doesn't necessarily mean that this webinar isn't in person. I've heard many say that you can have an in-person hearing within the meaning of the ICC rules, even if it's virtually in person. That's obviously an issue for individual tribunals, individual national courts in annulment or recognition proceedings. SIAC rules, many other institutional rules don't have that type of requirement. And as I think Guled mentioned, instead give very broad discretion to the arbitral tribunal, which almost certainly doesn't require a physical hearing as a matter of institutional rules. What about the Cairo Regional Center? What about the institution in your backyard, if I can put it that way? Both what do its rules say and what has practice been with respect to virtual hearings there?
Sure. Two things. Now, of course, the ICC as well has cases seated in Egypt, but as a matter of fact, the ICC rules, even though they make reference to in-person, there is reference to video conferencing, electronic means in the appendix dealing with expedited proceedings. And the the guidance note by the ICC makes it clear that this is not against the rules to proceed virtually. And I fully agree with you. In fact, it's one of the points that I made, and Mike is well aware of that we are appearing in person virtually. The very fact that the proceedings or we're appearing electronically or virtually does not mean that we're different people. We are very much the same people. This is just the comfort on that front. Now, in terms of the Cairo Center, and even throughout the region, there isn't an express reference to virtual hearings or using technology in the rules, except, and even the arbitration law in Egypt. But there has been guidance, let's say directives by the Cairo Center, which has been circulated to users of the center, saying that, of course, tribunals take the lead on this, but people can proceed virtually, and that the center is prosecuting cases and conducting business virtually as well now. So there hasn't been a big issue or a big fuss on this front so far. And in the UAE, it might be even lesser of an issue because their new arbitration law, law number 6 of 2018, makes express reference to video conferencing and electronic tools available to the parties, which makes it much easier if it's the seat of arbitration, of course, for institutions operating there to accept the fact that video conferencing would not be considered as a procedural anomaly, giving rise to any setting aside actions. So pretty much institutions are adapting. They are giving guidance notes and instructions about the efficient conduct of the proceedings. But then the caution is, tribunals have to consider this on a case-by-case basis. Now, of course, there are situations where, for good reasons, people may not have access to technology, reliable internet connection. Then we look for different alternatives. But again, one word of practical experience that we see is that when counsel or a party challenges the virtual hearing option, I think it is no longer an acceptable challenge to say that I don't want it or it's not preferred. You need to show why you are unable to proceed with a virtual hearing. And this is a tip that is important because tribunals are facing these questions on a daily basis, and they need to get some tangible evidence why a virtual hearing would not work.
Hey, Gary, could I jump in just briefly on this and point out?
By all means, Michael.
Yeah, in Switzerland, just as an analog onto this sort of, whether in person means, physically in person or not. And I think we've all agreed that even the ICC guidance note says you can interpret that to mean virtual. But we actually had an ICC case where neither of its place of arbitration is I think Geneva. It's in Switzerland, and the neither party nor the arbitrator is Swiss. And this case, the arbitrator, I think, did something I think was good practice, which is to ask the parties, is there anything under the law of the seat that would prevent the hearing, if we have to hold it virtually, being conducted virtually? Both parties researched the issue very quickly, which you can do these days with Google, and you find that the Swiss courts themselves have issued a guidance note saying that their own hearings are going to be done virtually through September. So I think that gave us all comfort that that was a way to proceed. But I would say generally, as an in-house lawyer, we're taking the view around the cases around the world that courts are just going to be unlikely to look back and say, because you did it virtually during this period, that's a violation of due process. I would tell you, as a user, I'm very skeptical that a judge, really in most around the world, would use that against us in a challenge proceeding. And I had a very, I would say, heated or somewhat confrontational discussion with one of our outside counsel in North America, who was very insistent on wanting to fly out and interview witnesses within North America, but couldn't do so because of the delay. I got a little upset. It's like, I don't want this to happen even after the pandemic. You should be able to use the virtual means as well. We need to see how the witness is going to react. It's like, you can do enough online to get to that point. I understand it's an important matter, but I think this is, again, part of the change that may remain with us.
That's very helpful. Before we move on to Fernando, just one other set of observations. I think lawyers, arbitrators in many jurisdictions have exactly the observations that both Mohammed and Michael have, namely, in person can be virtual, and a virtual hearing, even over one party's objection, doesn't raise either equality of treatment or due process concerns, unless, of course, there's some sort of gross disparity in access to technology or some other special circumstances. Although that, I think, is the intuitive reaction of many of us, particularly when national courts themselves are conducting virtual hearings, there are jurisdictions where, at least reportedly, there's a difference. In China, for example, I've heard from several quite authoritative sources that a party has a right to an in-person, as in physical, hearing, and that if one party objects, an arbitral tribunal can't order a virtual hearing. You need consent to a virtual hearing. That may be true in other jurisdictions as well. There's commentary in Germany, for example, that the German version of the model law requires a physical hearing as opposed to a virtual hearing. We all, I know, have our own immediate reactions to that. But let's move back to Europe, to Paris with Fernando, Paris, Madrid, as well as Latin America. Fernando is, I think, like others on the panel, a uniquely international creature. So your take, Fernando, from the Southern Hemisphere and the Northern on these issues.
Thank you, Gary. Listen, Gary, listening to you all, I beg to disagree a little bit about this being a revolution. Actually, I think that many of the tools and the fact that we're using virtuality in hearings, I mean, has been in the field already for years. What I think that is changing is that now we are aware that this can be used seamlessly, and that probably we were too much relying on physical presence for some things that were not really necessary. But I don't see the revolution. I think that as soon as the pandemic will be over, physical presence in hearings will come back. Probably not as much as before, but I think that we are not ready to go to a fully virtual arbitration world. And the reason why I'm mentioning this is because, and I make the bridge with Latin America. In Latin America, virtuality and technology has been present even in the courts for many years. So none of the issues that I have heard that may arise in certain jurisdictions concerning whether due process is respected by using virtual hearings normally should arise in most of Latin American jurisdictions. First, because again, I mean, we have had a kind of proverbial problem with clogging in the courts. So courts have been relying in virtuality and new technology for already some years now. And second, because most of the Latin American jurisdictions have reformed arbitration laws recently. I mean, I'd say the last 10, 15 years. And all of them have kind of embraced, quotation marks, modern arbitration. So that's not really an issue. In domestic arbitration in certain countries, you may have probably all arbitration rules that may require physical presence. But again, I have had the experience of arbitrating with local institutions in purely domestic arbitration, at least in 3 jurisdictions, lately in Colombia. And hearings, because I am based in Paris, and the place of arbitration was Bogota, and all of the hearings were conducted virtually. Because I was the only member of the tribunal that was outside Colombia, it was not worthwhile to increase the cost of the arbitration by making me fly over to Bogota, and therefore the hearings were conducted virtually, at least with me. I mean, that's the particularity. And that allows me to go now to my first proposition, that this is not a revolution, because what is changing now is that the entire hearing is being virtual. And that's I mean, we have to recognize that this is new. I mean, to have a full hearing virtual. In France, of course, I mean, being one of the most liberal countries in international arbitration, this is not going to be an issue, and it's not an issue at all. I think that the situation of virtuality presents more of pragmatical issues rather than legal ones. And I can just tell you this on the basis of my most recent experience with a fully virtual hearing, which happened as recently as the day before yesterday, in which I chair an arbitral tribunal, in which we were prepared to have a physical presence hearings before the confinement. And the parties finally, together with the arbitral tribunal, came to agreements that I would like to share with you, because I think it's a great experience. First, parties and the tribunal agreed on bifurcation. So we considered that there were issues, serious issues of jurisdiction that deserved to be treated apart, and therefore that was one point that probably we should take advantage of the technology and rely on these particular issues in a virtual hearing. So was a decision to bifurcate. There was a decision that for that aspect of jurisdiction, no need for request for documents was necessary. So we were kind of being conscious that we needed to preserve dates that had been set apart for the physical in-presence hearing and to keep it that way. No witnesses, no experts, jurisdiction, and just a hearing for allegations by the parties. It was a one-day hearing, but we had parties coming from Europe, 2 parties coming from African countries, arbitrators essentially based in Europe and Africa, and 1 party coming from Asia. And we were all connected. And the points that I would like to share with you, because those were the points that we were more kind of conscious that could raise difficulties, were the possibility to have kind of alternative means if one of the platform failed. We used WebEx, but we had immediately ready to jump into BlueJeans if need be. Second, we had our administrative secretary for the arbitral tribunal that acted as a host for the entire group and took control of the entire technology of the hearing. Practical view, in my personal setting, I was in the office. I had 6 screens because there were PowerPoint presentations and there was a hearing bundle. And also I wanted to be sure to know and to have the people that was participating in the hearing in a full screen and another screen to have the documents, the presentation of PowerPoint, an additional screen for having all the connections that we were having, because there was also a live note script that was being taken. We had to issue particular instructions concerning etiquette at the hearing. And something that I just want to mention, because it was an important point that was discussed between the parties, was the prohibition to use a virtual background. And everyone wanted to know who was behind the people that was appearing at the hearing. And we had an hyperlinked file at a disposal of everyone that was loaded, and everyone who had access to that hyperlink file. So, and finally, there was, and I think that this is also extremely important, a parallel channel of communication among the members of the arbitral tribunal. Because of course, I mean, we were not in the same room, and it was important to have the possibility to deliberate. So this, my summary here is that we are facing particular circumstances. I think that the particular circumstances, what have shown is that probably although the tools were there and the possibilities were there, we were not that reactive to change. And this has forced us to take advantage of what we already had and we already knew was possible to make. Parties are becoming more and more reasonable. I will end up my short presentation with another example that Mike knows, because I was referring to a very simple hearing, jurisdiction, only allegations by the parties. At the same token, we were preparing a different arbitration. This time I am counsel for one of the parties in a very complicated construction case. The place of arbitration was a Latin American country that has been particularly affected by the pandemic. And of course, there was no means to have a physical present hearing there. We decided to postpone the hearing that was provided for a 2-week hearing, to postpone it for November, December this year. And the whole discussion, and the discussion is going on, is how possible would be to hold that hearing virtually, at least partially. And so now it seems, and I cannot give more details because it's an ongoing case in which I am counsel, but for the time being, the discussion with the arbitral tribunal is that we have set aside 2 weeks with 2 weeks in the middle. So we will have a kind of 2 different hearings. And what is being discussed is to try to do a part of the hearing virtually and part of the hearing with physical presence, if by then it is possible to have a physical presence in that country. So this is what I consider is really changing, which is really the approach and the reasonableness of the parties and arbitrators trying to really to make of arbitration what arbitration has always been, which is a best alternative to court litigation. Thank you, Gary.
Mohammed, I think you had an observation or no?
Yes, just quickly, and I think Fernando's presentation is extremely helpful. 2 points, and I fully agree about the alternative platform, but I think one of the essential points now we need to consider with virtual hearings, alternative internet connection, because if you have a problem with the connection, an alternative platform will not work as well. So I think this is the problem that many people are facing when it comes up in virtual hearings, POs or directives, is what sort of alternative connection do you have? And you know, some people say, you know, we don't have an alternative connection, and that is an issue. But on the last point Fernando has mentioned, again, in one of the major cases where I'm currently sitting as arbitrator, so I'll be very brief, where it involves a state entity, there are no reliable internet connection apparently in that jurisdiction, and we're sitting in a different place, and we adopted the hybrid form of hearings. So the parties agreed to do their openings virtually, possibly expert examination could proceed virtually, but it seems that the people are distinguishing fact witnesses and pushing more for an in-person physical appearance and cross-examination of fact witnesses. And that's where we also set aside some time on around the last quarter of the year, but we made it clear as a tribunal that we do that, noting that if it does not proceed physically, we will proceed virtually. So the parties need to consider from now up until then what options they have to prepare for that hearing to take place either physically or virtually. But is it an important and interesting point of distinguishing fact witnesses and expert witnesses when it comes to cross-examination?
I think if I can interject something, Gary, rapidly, I mean, two points. The first point, and I think that's a critical point, is equality of parties. I mean, so far this was an easy hearing because everyone had access to internet and good technology. It may not be the case for every party involved, and that may raise serious issues of due process. So that probably is the one caveat that I would do to whatever I mentioned before. The second point is that I think all agree that when you are doing cross-examination, be it factual witnesses or expert witnesses, I mean, virtuality is far from ideal. So I think that those 2 points are the points that we will have to keep in mind, because even if we all embrace technology, those limitations will have to be taken into account by arbitral tribunals.
That's very, very interesting, both Mohammed and Fernando. Couple brief observations before we hear from Evgeny from Moscow. Number one, Fernando makes the point that one screen isn't enough. Janet Walker has done a very interesting presentation on the technology that you need for virtual hearings. She prescribes at least 3 screens, as well as, and this is a rule that I think all of the panelists today are violating, no natural light and a separate webcam. Fernando now says you need 6 screens. That is going to be a tall order for many of us. Our living rooms, our studies may not be quite that large. What though, your thoughts about that, Evgeny, but also what about the proposition that cross-examination in a virtual hearing is not ideal, not desirable, arguably not doable? Is that right? Is cross-examination something that is uniquely difficult? I have personal observations on that from both counsel and tribunal perspective, but I'd like to hear other thoughts about that. Evgeny first, from Moscow, your thoughts on how the pandemic is affecting arbitration in Russia, other observations on what you've heard in the last 45 minutes.
Thank you very much, Gary, and good afternoon, colleagues. And pleasure being invited to this very interesting session. As other countries, we have been heavily involved in learning how to use modern technology to run virtual hearings. And I had myself several opportunities to experience the benefits of technology. Jumping directly to the question which you just put, Gary, about experience in cross-examination, my experience is positive. We just had a very interesting and long hearing in the High Court of Justice in London, with part of the hearings run from our office, where witnesses had to be cross-examined, and part of the hearings run from London, where our Queen Counsel cross-examined the other party's witness, and it ran smoothly. The opportunity to grasp information, to listen to what is said, was fine, and everything was available. A transcript was run in real time. Of course, we used the same firm as everybody's using in London. I wouldn't name it, but as a professional supporter. But this showed to me how important the technology is, and as already has been said, now the inevitable part and one of the most important participants of our legal teams is IT person. And I would predict that firms who invest heavily in the IT, who are prepared to this situation, and also invest into the infrastructure, like the necessary number of conference rooms, would have the market advantage. Because if we take this pandemic situation, for instance, what I realized, you invite a witness to be cross-examined, but you need to provide a separate conference room to keep the witness safe. Or you need to have a conference room big enough to keep the distance between counsel and witnesses. The other party wanted to be present to observe that witness testimony is taken without any interference. So you need enough space to accommodate representatives from the other party, which we had. Actually, we booked the whole floor for the day of the hearings, 5 or 6 conference rooms. You need breakup room. There are technological platforms which allow virtual breakups. I haven't used it, but I read that they are, and this is a big advantage. But of course, people, if possible, prefer to speak physically with their counsel, if, for instance, client and counsel are present in the same location during virtual hearings. So these are all things, and I agree with the speed of the internet connection, the quality of the channel. This all goes without saying. So software and hardware are important. And if we take the Russian court's position, the approach has been, I would say, cautious, moderately cautious. From one side, the court started to run virtual hearings, but from the other side, the consent of both parties was needed. And of course, it's not possible in all situations. I would say in 70% of cases, it's not possible to have mutual agreement of both parties. On the other side of the spectrum, we have the High Court of Justice, where the judges don't ask for both parties' consent, but demand that parties cooperate and figure out how to run hearings virtually. And Russian parties who are heavy custom litigants to the High Court and to London arbitration had to learn this new way of running the cases because they just couldn't refuse referring to impossibility to travel, and things will just run without their participation. So they have to accommodate. From technological perspective, we are quite well developed and prepared, and there is no problem to run the hearings on various platforms. Though I think that in the nearest time, and I suspect that part of the driving force will run from SIAC, there is a need of some sort of international protocol. Like in the past, the courts started to cooperate on running complex trans-border bankruptcy cases, for instance, because we can't use different platforms. There should be some standards like PDF, for instance, which everybody uses. I think this is the need of the nearest future, which we have to take into account. Another obstacle, which is quite artificial, but still, what I experienced myself is, for instance, so-called electronic signature. When you prepare documents, for instance, trial bundle, when you file some documents electronically, some countries are still quite formalistic, like Russia, for instance, or Latvia. They demand that attorneys assign the authenticity of the documents with the so-called electronic signature. And I just had experience recently where my colleague in Latvia could not do it just because of the storm and thunder. He could file the document, but without electronic signature. And actually, my experience shows that when we go to trial bundles, it's all unregulated. In arbitration, it's more flexible. It's good that tribunal can accustom the rules and put down any rules that are unnecessary. However, if we take countries like Russia or like Germany, or even France, where courts stayed almost locked for a long period of time and just started to open, there is a tradition of running the matters on papers, which is not so widespread in common law countries. The judges in our countries are fine to do things on papers, especially deciding various procedural matters. So we need some kind of universal protocol. Of course, it's necessary to switch more and more to electronic forms of documents. However, procedural codes are still what they are, and they are not changed. This situation was force majeure for due process, for civil procedure. Many principles became more flexible. The English court, for instance, demanded that solicitors to the parties put in advance reference to the hearings to follow the rule that all hearings should be open to public. However, when my colleagues wanted to connect to the hearings, which I was talking about before, they could not find this reference. However, journalists could find it. So I think these are all technicalities, but important things to be accommodated. And the success of this story is that, according to statistics, in April, 1/3 of all hearings in London were run through video, and 1/3 were run through audio means, which I'm not sure the situation in Russia, but in May, the Supreme Court of Russia held the hearings of special session on analysis of the court practice, where about 85 judges and legal practitioners joined remotely, and only the chairman of the Supreme Court and his deputy were present in the court's building. So the situation is moving on, and of course it's changing. What also I wanted to mention, which you mentioned, which is very interesting that you heard about it, the latest developments in the Russian law, not connected to the pandemics, but connected to earlier difficulty, which is sanctions or restrictions, like our legislator calls them. Surprisingly, even to me, the amendments which were quite widely spoken about for the last 3 years were suddenly passed, and they're going to become the law on the 19th of June, in 2 days. Essentially, this is kind of a revolution for Russian law. There was big difficulty for the Russian parties who are sanctioned to take part in the international court proceedings in other countries and international commercial arbitration proceedings when they couldn't, for example, pay their arbitral fees. And we have such case even in our docket. And now there is an opportunity to bring the case where the Russian party which is sanctions takes part or which is connected to the sanctioned party into the Russian court, and Russian courts are told to have exclusive jurisdiction over such matters unless parties waive this exclusive jurisdiction in the jurisdictional agreement or the arbitration agreement. So the first lesson or rule is, again, the basic thing. The arbitration clauses should be drafted very carefully, and if you don't want your issue to be heard in the Russian court later on, you should just make a carve out in the arbitration agreement or add special terms to existing arbitration agreement if needed. And these norms are they regulate not only parties who are sanctioned directly, but also parties who fall under secondary sanctions because of breaching Russian sanctions. The second norm is anti-suit and anti-arbitration injunction, which is absolute novelty. We had many cases when English courts imposed anti-suit injunction against proceedings run in Russian courts, but Russian courts were always reluctant and refused anti-suit injunctions because they considered it as an intervention into sovereignty of other states. Now the party can ask for prohibition order from the Russian court against running the case or arbitration. It can be also anti-arbitration injunction in the foreign forum outside of Russia. And the party must justify why it cannot participate in the foreign court proceedings or foreign arbitration proceedings. If this injunction is breached, the Russian party can claim damages, but the amount of these damages is kept with the amount of the claim which is filed in the foreign court or arbitration which was injuncted. So that's quite interesting. Of course, there is no court practice yet, no commentaries, and Russian practitioners are quite puzzled how this going to correlate with the laws of the other countries and international law. However, as I said, this is quite an acute issue, because when you start to think how many companies and physical persons are touched by this new reality, this is a big thing. So basically, this is how the situation is currently from Moscow.
That's very interesting, Evgeny. I think we could have a separate webinar on the final topic that you touched on.
Can be, yeah.
Perhaps we have around 10 minutes left now, and I know that there will be questions from our participants. Before we do that, though, and I haven't warned my panelists about this, how about a quick poll? A poll on the following question: in the arbitrations that you're involved in any capacity, what percentage of those are going forward with a virtual hearing over the objection of one party? Put aside cases where you have virtual hearings that are consented to by both parties. Think about the universe of cases that you have where one party wants to go forward, typically the claimant, but not always, and the other party resists, says, I do not want a virtual hearing. In what percentage of cases that you're involved in are tribunals nonetheless ordering a virtual hearing? And perhaps we go in the same order that we have had the principal presentations, Michael, Guled, and following. Michael.
Well, the percentage is hard. I'd have to do the math quickly, but I can think of, I have one I have one arbitration. I think it's ICC. Yeah, that I think that the other side has objected, and I think that it is going forward. It just, there's no determination has been made as to whether it will be virtual or not. And I think that's appropriate to, why would you have to decide this now for something that might take place in some months, and we'll see where it is. I have one case where it will not go forward over one of the, but this is actually a court case. It was a court case was scheduled for 40 days in a country that likes to have North America, one of the two countries of north of Mexico, that likes to have very, very long, complex trials. And this was one scheduled for 40 days with many experts and witnesses. And in fairness, I think that is a case that, I think while in the new world, the default may well be, we can do virtual, why should we do in person, physically in person? I think there will be some cases like this one where you can make a very good case that, and maybe that was one where the stakes are so high and it's so complex and there's so many people that maybe you do want to do that physically. So I can come up with one and one right now.
Okay. Guled, your experience, A&O's experience.
Yeah, I mean, I certainly don't have any matters at the moment where there have been objections to going ahead. The debate has really been much more about the parameters of virtual hearings, and then keeping the possibility of an in-person hearing open depending on what happens. I mean, people are crystal ball gazing a little bit as to when things will normalize, and that's quite difficult. So everybody's been quite flexible. The other issue that's been in debate is the exact timing of the hearing, obviously, as a result. There's been discussions about whether hearings should take place sooner or additional time should be granted to make sure all of the requisite preparations are made. And I think everybody here and many other practitioners have been stressing the importance of practice before having the actual hearing. So those have been the main points of contention. I'm afraid I haven't experienced an objection to virtual hearings in the absolute sense.
Okay, so we're still at 50-50. Mohammed.
So I have an answer for you, and I want you want an answer, but let me group them the following to be precise. So in case of objections, I would group them into in case of unreasoned objections. So there was no reason whatsoever apart from the fact that when we agreed to the timetable, we agreed to a physical hearing, and that's what the tribunal do, and they can't do anything else. So in that situation, the statistic is 100%. Tribunals were not convinced that you need to give us something. So in case of reasoned objections, here it's about 60% that we've decided, proceeding with a virtual hearing, but this 60% is qualified because out of them, having done the math, 80% of the 60% were hybrid cases. So we've had elements of postponing for a physical part and proceeding virtually on other parts, and 20% wholly virtual out of the 60%. Does that give you an answer?
It gives me a complicated answer. Fernando, can you simplify or make more complicated? Your choice.
Now, very, very simple. For hearings taking place during the pandemic, no objections, everyone agreed. I mean, I think that the parties wanted to proceed as smoothly as possible. The real issue, as pointed out by Guled, is for hearings that will take place later on. And so with a kind of question mark, what the restrictions would be. And then there has been an objection by me. And that objection was partially upheld. And therefore, we are planning to have a physical presence part of the hearing. That was the case I was mentioning before.
Interesting.
And just to complete, I mean, on Mohammed's analysis, it was, of course, a reasoned, well-reasoned, and completely justified objection.
we have no doubt. Evgeny.
I can't say I'm sitting in the arbitration now as arbitrator, co-arbitrator, where me and my colleagues are actually pushing for the hearings, trying to convince parties, and parties are trying to convince us that the case should be just adjourned. And unfortunately, they're doing it at the very last moment, like it's quite often done in Russia. My experience is that arbitrators are quite cautious because in Russia, the level of your procedural, I would say, creativity and robustness would rarely be higher than that of the courts. This is a sort of limit where your procedural decisions should be tested. And the courts, as I said, are quite conservative, while in England, for example, they are more flexible and robust. And I can suppose that arbitrators can also be because they can be sure that their decisions wouldn't be criticized and their awards wouldn't be challenged.
No, that's
Gary. You did. Sorry, go ahead.
Sorry. No, I just want to draw attention.
Mohammed.
Okay, sorry, Michael. Yeah.
No, just say that you didn't ask the question, but I would say that in my experience, Gary, people are not objecting for the most part. I've been surprised in my cases that these tend to be cases that are, let's say, smaller in some of your worlds, so, below the 5 million amount. People have not been objecting. It's been people, I think, recognize that this is a time where objecting kind of makes you look unreasonable.
No, of course, this is, Michael, this is helpful, of course, but there are cases where you've got like 10, 15 witnesses and hundreds of millions, and people don't want to put this to test. So Gary, the point is, I see no one asking that, and perhaps we can take a poll on it. What happens if the parties both agree to postpone and they don't want to have a virtual hearing? Do the arbitrators have the right to police them into upholding the virtual hearing by the time agreed? I'm saying that because I faced that in a case as an arbitrator, and my thought was, if both parties agree to postpone, we should not do anything. It's not like they're postponing for a couple of years. We can find something reasonable. And, the arbitrators sometimes, they just want to get done with the case, and that's it. So I would be interested in your thoughts.
Excellent questions. We have about 5 minutes, and we do want to get to Q&A from the audience. Just very briefly, and speaking from my own experience, in a substantial number of cases, perhaps it's because the cases I've been involved in have been on the larger, more complicated side, parties do object. In particular, respondents object to conducting a virtual hearing. One can, in some cases, surmise or suspect that the objection isn't really to virtual hearings, but to the arbitration going forward. They'd rather have claims against them not resolved as opposed to having them resolved. I do think there is likely a difference in attitudes among parties depending upon the size of the case. I think parties with smaller cases where, in a sense, it's more a question of claims handling, claims processing. This is not a bet the company case. We could win this case or lose this case. Let's just get it resolved. I think in those sorts of cases, virtual hearings are very unlikely to raise much by way of objection. I do think in larger, more complicated cases, both because parties care more about whether it's decided correctly or not, because those cases tend to be more complicated, and therefore parties intuitively think that an in-person hearing will be more efficient, more expert, that you're likely to get objections. Very briefly, to Mohammed's provocative question about what happens when both parties don't want to have a virtual hearing and the arbitral tribunal does, that's reminiscent of the late Johnny Vita's great question. Whose arbitration is this? Is this the party's arbitration, or come hearing time, is this the arbitral tribunal's arbitration? The basic rule, of course, that we all know from the model law and otherwise is party autonomy. If the parties decide they want an arbitration in Mandarin conducted virtually, they can do that, notwithstanding the tribunal's contrary views. Many institutional rules, though, UNCITRAL rules, LCIA rules, some other institutional rules, actually on a close reading, give a fair amount of the party's autonomy back to the tribunal and give it, at least in theory, the authority to override the party's procedural agreement if the tribunal concludes that that would be more efficient and more fair. I think tribunals are very reluctant to use that authority, assuming that they have it, over the party's objection. No tribunal wants to order both parties to do something that neither party is willing to do. But that said, when the rubber really hits the road, when the question of who has the ultimate power is presented, there is a non-trivial argument that a tribunal, under rules that give it the authority, notwithstanding the party's agreement to order particular procedures, can in fact do that. I suspect most tribunals won't do it. But let's turn to Piyush very briefly. Questions that you think we should be addressing, Piyush?
Gary, we don't have any questions from the audience, but I wanted to put a question to the to the panelists. Evgeny, you mentioned about an international protocol that which can possibly help and streamline this situation, and in which we are all facing as to what to do. But isn't it better, as we all know that the rules provide that flexibility? So would you not just leave it to the tribunal and rather than standardize and have an international protocol?
Let's get everybody's views on that just really quickly. Perhaps we go in reverse order this time, starting with Evgeny. What is better? Should we have a uniform international protocol, a new IBA guidelines on virtual hearings, or should we let things develop more in a common law fashion? Some parties may want Zoom with particular features. Other parties may want some other platform, some other set of protocols. What's the best approach for the time being? First Evgeny, then Fernando, in reverse order, and then we're done.
Well, I always stand for diversity. So there are several platforms on the market, which you mentioned, and there probably will appear more in the nearest future. However, there are essential features of the procedure which should be followed. So if tribunal can offer the parties to express their views, then tick the boxes, for instance, confidentiality, possibility for confidential communication between client and counsel, so on. And if this is satisfied, the platform can be chosen. I doubt there is a need for IBA guidelines in the nearest future on that. However, the arbitral institutions like SIAC, like other prominent institutions, should think about, I would say, soft recommendations for tribunals, what they should look for, starting from reliable internet connection in the place where a witness is supposed to be cross-examined, possibility for virtual parallel translation and so on. This I think is needed. And then after that, when we can assess this recent practice, when it's going to be tested in courts, and when it stands, when courts support it, these various approaches, I think we can come up to some more or less universal model, because this is still technology.
Right, Fernando.
Yeah, I think I tend to agree with Evgeny. I think that we don't need more international protocols. What we need probably is a sort of things to think about for guidelines for arbitrator. But again, that would be for the institutions if need be. I don't think that is any need for guidelines. And I just answered your previous questions. I mean, no doubt that the arbitration belongs to the parties, Gary. And if the arbitrators are not happy with the decision or the agreement of the parties, they always can resign. So that is not really a big issue.
Mohammed, no guidelines, no UNCITRAL notes on organizing virtual hearings. You're on mute.
My immediate thought is that no guidelines on this, no one size fits all. And for us to consider guidelines even, they need to have stability. And the market in technology is exceedingly changing, and we can't do this. What we can do is consider minimum standards, because technology in a span of 6 months changed completely, and we will be laughing at the applications we have at the moment because they will very soon be outdated.
Well, Oliver Wendell Holmes Jr. famously observed that the life of the law has not been logic, it's been experience. And so I think if we're all as practitioners in arbitration centers able to share our experiences in virtual hearings, identify practical recommendations, issues that have come up, as Fernando mentioned, checklists, those are all helpful. But I don't think a mandatory protocol or rules is the way to go.
Another full-throated endorsement of the common law approach. Michael, any dissent?
Both. Both. And I'll tell you, but not necessarily all right now. I think right now it's a terrible time with the pandemic, but I think for international arbitration, it's an amazing moment. There's just a flowering of great ideas. Mohammed shared a protocol that he wrote, and maybe it's more of a guidance as to how you do things. And I was already using it before he even published it, because it came in, it was really useful. It's more than a protocol to adopt. It's actually a thought process as how to address the issues when you see objections. So I think I wouldn't want to do anything that would codify, while we're all trying to figure things out right now. But to say, should there be an IBA, maybe at some point in the future, why not? Or when the next time there is an updating of the IBA rules of evidence, why not take into account, things that we have learned right now when witnesses can't appear and how to handle things virtually? I mean, I think that sure.
That's interesting. We have a diversity of views here, but I do think there's one common theme to what everybody said. And that common theme is spring is here and summer is coming. As Michael put it, there are flowers blooming in international arbitration. That's certainly the case at SIAC. Our caseload is well above last year, which, as I think all of our viewers know, was the year with our record number of cases filed. We've had both normal arbitrations and emergency arbitrations going forward virtually. And the Secretariat, as you can see from Piyush's stewardship of this webinar, has been fully engaged, notwithstanding the offices having been closed during lockdown. It is indeed spring, summer, fast approaching. With that, though, let me thank in particular all of the members of the panel. I think we had a unique geographical, if not other, diversity and a healthy, fruitful exchange of ideas. Most importantly, let me thank all of the viewers, the attendees. We know that you have other things to do, notwithstanding lockdown, and we appreciate your taking the time to hear what we at SIAC have to share. With that, thank you very much, and I think Piyush will sign us all off now. Thank you again.